Afternoon and welcome. Thanks for joining us for the fourth and final webinar of our October Money Matters series, co-sponsored by the Friends of the Sacramento Public Library and the Sacramento Public Library. The Friends are honoring Library Director Rivkah Sass, who will be retiring at the end of this year. The Young Readers Fund is an endowment in her honor to nurture young readers. To find out more about us or the Young Readers Fund and how to contribute, visit us at saclibefriends.org. I'm Karen Wilson, president of the Friends of the Sacramento Public Library. Our Money Matters sessions have covered a wide range of subjects on how to keep your finances safe and working for you. But a complete financial plan looks at the legacy, financial, professional, and personal, that we want to leave behind. Our topic today is building a lasting legacy, how you want to be remembered. Our speakers are Rivkah Sass, Sacramento Public Library Director, and Anne Rosenthal, Managing Shareholder of Drobny Law Offices. Rivkah has been the director of the Sacramento Public Library for the past 12 years and has created a strong legacy through the library's outstanding service to our community. Rivkah has thought deeply about ethical wills and other means by which we may be remembered for a life well lived. Anne Rosenthal is a certified specialist whose practice emphasizes estate planning, trust and probate administration. She counsels clients in implementing estate planning strategies to minimize taxes and shift wealth to future generations, and also assists clients with their charitable giving objectives and special needs planning. So a few housekeeping issues before we get started. Please put your questions in the Q&A at the bottom of your screen, and Anne and Rivkah will answer them at the end of our program. If you need to access closed captioning, you can click on the transcript button at the bottom of your screen. If you post in chat, remember your comments will be public, so please keep them respectful. And a recording will be made available on the Sacramento Public Library's website, saclibrary.org, later this week, as well as being uploaded on their YouTube channel. So now, first we'll hear from Rivkah and then from Anne, and we'll have your questions. Welcome, Rivkah.
Thank you, Karen, and good afternoon, everyone. Make sure that my sound is okay. I'm sometimes not sure if it is going on and off on this very expensive headset, at least in my opinion. I'm very happy to be here. This is one of my very final presentations as director of the Sacramento Public Library. I have one more, and then I just work my time for the next few months and get to be a library user and enjoy all the wonderful services and programs at Sacramento Public Library. This is a subject that's actually near and dear to my heart, especially as I think about my career of more than 40 years of being a librarian and, being a parent and now a grandparent. Karen just used the words "a life well lived." And that's, I think, what we all hope for when we get to the seventh inning stretch, I guess we might call it. And I'm so excited about Anne's presentation. She spoke just a year ago on October 22nd about the same topic. And it's really what takes center stage here today. But, I keep thinking about what do I want to leave behind, having been library director here for 12 years, and what do I want to be remembered for? So this is a very personal presentation for me, but I'm actually quite excited to share my thoughts with you. We have our personal lives, we have our families, we have our friends, we have our professional experiences. And as we combine all of those things and think about where we've been and where we'd like to go, we always have to think about what our legacy might be. And really, to me, it's an act of love. It's about letting others know how much we care about what they've done, what they've contributed to our lives. And, that's a very important part of it. And so as I think about that, I think about some things that I've learned over the last couple of years that I really want to share with you. And that is, it starts for me, and I was very lucky to go through a a sort of a tutorial a couple of years ago, pre-COVID, thank goodness, about what do I want to leave behind? And the concept of an ethical will came up in the conversation. And it really helped me to write things down. It can be done in writing, it could be a video, it could be a voice recording. But as I think about what I want to make sure that people know about me, mine is written. I'm a word person. After all, I'm a librarian. But it's meant to highlight your guiding principles, what really nourishes your soul. What did you get joy from? It's your memories, it's your spiritual values, and it's your wishes for your family's future. I have two very young grandchildren. One is just turning 1 on November 9th. The other one will turn 3 at the end of February. And it's a delight for me. They don't live here in Sacramento. It's a delight for me to see how they're growing and how their curiosity about the world changes every single day at that age. And, sharing those stories, their stories with them eventually about their mother, who is my baby, and how those family memories, pass those along. There are lots of helpful articles and probably YouTube videos and everything else on how to create an ethical will, whether you want to include photographs or scans of letters. We have all of this technology at our fingertips now, so you can make it truly a very rich three-dimensional experience for people. So you can find those just by searching on the term ethical will. And I urge you to do that, because I think that's a good starting place for all of us who have that idea of leaving a legacy behind. It also is about passing on your skills. I wish I had learned more carpentry from my father, because he was great at fixing things and building things. And I have a real love for wood, and I like to refinish furniture. And that really is his legacy to me. I learned it from him. I wish I had learned a little more, because I'd like to be handier, but that's another skill. But think about what talents you have and what you can pass on. That's so important and so meaningful to the people that you care about. It's teaching your grandchildren to play chess. For me, it was reading to them every day. It was passing on what I had passed on to my children and what I see them now passing on to theirs. It's about being curious and hungry to learn. So I think those are things, whether it's playing chess or how to make the world's best pie crust, which I believe my grandmother possessed that particular gene and fortunately passed on a pretty good portion of it to me. Those are kinds of things that I think about and do that for your for the people that you care about. The other is, we all make mistakes in life, and we all have difficulty with some relationships, and maybe even burn a few bridges. Reconcile those relationships so that you don't go away mad. My parents always taught me, as mad as they could get at one another, they always taught me, don't go to bed angry. It's not worth it, and it doesn't work for you. Make up. Well, do that with your relationships in real life as well. And I think, honestly, a truly important thing, and I've learned this about myself, especially in my time here as director of Sacramento Public Library, what are my core values? What is really important to me? And I am a very mission-driven individual. It's been so important to me to share the love I have for the work I do, for being a librarian, for building community around literacy and learning and connecting with people, that I want to be remembered for that. I want to be remembered as somebody who cared about community. And I've been reading a lot lately about relationships, as you know, we're pretty torn apart as civilization, as a civic society right now. But I've thought about that a lot, and I've been reading. I just finished reading The Power of Strangers. I just downloaded another book called Survival of the Friendliest, and just heard a talk on Zoom by Dr. Brian Hare from Duke University. It really is about how we connect with one another. And that's so important for me. And I know that that's one of my core beliefs. So I think it's important to understand who we are, what matters to us, and then share that with those we love, but also live your life that way. And I think as you listen to what Anne Rosenthal has to say, and it's such good, deep, rich information that you'll receive, you can think about what your legacy is. Is it about leaving behind, and I believe it is, the essence of who you are, so that future generations can experience that, appreciate it. And it's far different from a financial inheritance. Let's face it, a lot of us don't have a lot to leave. You know, we might have something to share with our children and others, but it's really about sharing that essence of yourself. And again, having had two parents who were born in the 1920s, who were young teenagers, who got married during World War II, who, you know, lived this life that I think even today we can learn from, and the stories that they told about rationing and how they all got through a challenging time together are things that I carry with me, and truly am grateful for. The only regret being that I didn't write down more stories, because they're gone. So I think I've said enough. Anne, I'm going to turn it over to you, because I think truly what you have to say is so important for today's audience. And I really appreciate and thank you for letting me share a little bit of my story.
Thank you, Rivkah. All right. So today we're going to be talking about building a lasting legacy and how you want to be remembered. And, you know, as Rivkah alluded to, so much of your legacy is dependent upon the type of life that you lead. That being said, families can be absolutely devastated, torn apart because of lack of proper planning. And oftentimes it is from persons that you would never expect. You know, people who were so organized and so vigilant in their careers, their home lives, their families, and just, you know, deferred any sort of incapacity or post-death planning because it was too difficult. So I'm hoping that today will be educational, informational, informative. Please put questions in the chat and we will get to them at the end of the presentation. So normally when I first meet with an estate planning client, the question is always the same. Do I need to have an estate plan? And the answer is no. There are multiple ways that you can pass your assets to your intended heirs without a will, without a trust. And one of the most common ways of doing that is by holding assets jointly. So let's look at real property for a second, because that is normally most commonly how joint tenancy is used. So A and B want to purchase a property together. A and B can be spouses, children, friends, or strangers. Anyone in California can own property jointly by putting on their deed, we take title as joint tenants. Let's say that something happens to one of the joint tenants. Do I have to go through probate? Do I need to hire an attorney? No, it could not be simpler. Joint tenancy by operation of law gives you a right of survivorship. So all that A has to do after B passes is file an affidavit death of joint tenant with the recorder's office. The recorder's office will then update legal title of the home from A and B to A alone. We often see this in a family scenario, spouses owning property together as joint tenants. And of course, they may have children that they also want to have that property eventually go to after their passing. So same scenario, something happens to one of the spouses, the second spouse files an affidavit death of joint tenant, and they now own the property alone. And of course, they think this could not have been easier. During this difficult time, I was simply able to take title individually without having to go see an attorney, without incurring expensive costs. I want to do the same thing again. Child one is my favorite child. They are so responsible. I'm going to put them on legal title as a joint tenant with me. Problem solved. Anyone see any issues here? Let's say that the surviving parent makes it very clear to their child, after my passing, I want you to divide this property equally among you and your siblings. And of course, child one, the responsible child, says, not a problem, you have nothing to worry about. The surviving parent passes away. The surviving child files the affidavit death of joint tenant and now owns legal property alone. How often do you think that child one is going to then share this asset with their siblings when legal title is vested in their name individually? I'm afraid I see worst case scenario every day, and I cannot tell you how many times if legal title is in one person's name, they have no obligation to share it with any surviving siblings. I also have issues back when they were put on title initially. The best and worst parts of joint tenancy are the same, and that is that you have an undivided interest in the real property. So even though child one is the responsible child, has never done anything wrong in their life, maybe they had one too many glasses of wine, maybe it was just a stormy night and they get into a car accident and child one is then sued. From a creditor standpoint, child one now owns this home, even though the surviving parent only put them on title to ensure an ease of passing of the asset after their passing. Doesn't matter. This is now an asset of child one, and it is open to all creditor claims against the child. So before you put a child on title with you, whether it's at a house, in a bank account, make sure that you are aware of the legal implications of putting someone on title and that their creditors and their liabilities now become your creditors and your liabilities. What about beneficiary designations? I think this is another way of avoiding having to do complex estate planning while ensuring that your assets pass to your designated beneficiaries. So let's look at retirement accounts, IRAs, 401ks, 457s, 403bs. All of these plans allow you to name a beneficiary, and at your passing, those assets will go directly to the beneficiary that you have named on those documents without any court involvement. This is often commonly used in an annuity, life insurance, and pensions as well. What about taxes? The way in which you leave assets to your intended heirs, beneficiaries, and charities will have enormous implications, not only on their taxes, but the taxes of your estate as well. And I'm afraid there's a whole slew of taxes that come into play when we are in the estate planning world. Income taxes that we are, of course, familiar with, gift taxes, estate taxes, inheritance taxes, property taxes, capital gains taxes. I could talk about these for days and days, but let's try and hone in on some of the most important ones that are going to affect your transfers. So let's look at capital gains tax. So capital gains tax occurs when you purchase an asset, that asset appreciates in value, and you then sell that asset. So let's say that I purchased a property for $20,000 and now it's worth $100,000. So if I then sell this property, I'm going to receive $100,000. That is the fair market value. That is what it's worth. What is my basis in the property? Your basis is normally your cost basis, whatever you paid for it. So since I paid $20,000 for this property that's now worth $100,000, that $80,000 of appreciation is now subject to capital gains tax. I don't feel like paying tax on $80,000. Let's look at a different scenario. I don't really need this asset. I don't need the proceeds of sale. My son, on the other hand, could really utilize the money. So what if instead I take this home that I purchased for $20,000 that is now worth $100,000 and I give it to my son? He's going to be receiving an asset worth $100,000, but what is his basis in the property now? He didn't buy it. I bought it and then gave it to him during my lifetime. His basis is the same as mine, $20,000. So if he then sold the property, he is going to be paying capital gains tax on the $80,000 worth of appreciation. And this is called carryover basis. And this occurs for any assets that we gift during our lifetime. So I can't tell you how many clients I have come in. They don't want to wait until they pass to give their assets to their children. And my first comment is always, what are the tax ramifications of you making a lifetime gift? So whether this is real property, stock, or securities, if you gift appreciated assets to someone during your lifetime, they will take over your basis, carryover basis. So I've decided that's not a good option either. I don't want anyone paying tax. So instead of gifting my $100,000 property to my son, I put it in my trust. I put it in my will, and I state upon my passing, this property will go to my son. So he's still going to receive a property worth $100,000 at my passing, but what is his basis in the property now? $100,000. Assets that you receive as an inheritance, whether it's through a probate, a will, or a trust, receive a step up in basis to their fair market value as of the date of death. So if my home is worth $100,000 at my date of death, and my son then inherits that home, his basis in the home is $100,000. If he then sells the home for $100,000, we are looking at a big goose egg. Zero capital gains tax is due upon the sale. Step up in basis. What about if it's a couple, or going back to our earlier example of a joint tenancy? We have two couples that own $100,000 property with their basis split between them, $10,000 each. Obviously, if they sell it as joint tenants, we have the exact same tax ramifications. There is going to be $80,000 worth of gain divided equally between the two joint tenants. What if one of the joint tenants passes away? So we know that their original basis was each $10,000, but upon spouses one's passing, their basis will get stepped up to the fair market value as of their date of death. However, because they are joint tenants, only half of the basis will receive the step up. So we have half of the basis getting the step up at spouses one's death, which wipes out all of the capital gains tax, while spouse two did not receive the step up in basis, and there will still be $40,000 of appreciation that will be subject to capital gains tax. What about changing title? I think it's one of the most common questions that I get when I have a client who wants to purchase a property. Does it really matter how I take title? You know, escrow is bugging me. My real estate agent is bugging me. Do I want to be a joint tenant? Do I want to take it as community property, tenants in common? I don't know what any of these words mean. Does it matter? It absolutely matters. So what if instead spouse one and spouse two took title as community property WROS, which stands for with right of survivorship? So we're still going to receive that same $100,000 amount for the property. However, if one spouse passes, both halves of their interest, because it is community property rather than jointly held, will receive a step up in basis. So just by changing legal title on the deed from joint tenancy to community property with right of survivorship, we have saved an enormous amount of tax and wiped out all of the appreciation upon the first spouse's passing. This will also occur at the second spouse's passing. So you are actually eligible for a double step up in basis in California. so that we can wipe out the capital gains tax if the surviving spouse wants to sell the property. And then we wipe out the appreciation again at the second spouse's passing before assets are going to the intended heirs. What about disability planning? I think it's a common misconception that estate planning is post-death planning. And more often than not, we are seeing clients living longer and longer. And unfortunately, oftentimes there are extended periods of disability as part of the aging process. Who's going to make financial decisions if you are alive and well, but you do not have the mental capacity to pay your bills and make correct financial decisions? Same for healthcare. Heaven forbid you are incapacitated, you're in a coma. Who is going to be there to advocate on your behalf? And honestly, the alternatives for not planning for periods of incapacity are some of the worst parts of my job. If you do not have planning in place and someone needs to make legal decisions for you, I have to go into court and get either a conservatorship of the estate for financial decisions or a conservatorship of the person for medical decisions. This is a grueling process. You're going to court, you're having a court investigator interview your family. This is not what you want to be going through at the end of your life. How do I avoid this? Durable powers of attorney. Everyone over the age of 18 should have a financial, durable power of attorney and an advanced healthcare directive. I think so often we think about estate planning and incapacity planning for our later stages in life. But I can tell you from experience, anyone over the age of 18 can need these documents. Unfortunately, my law partner, his son goes off to college, he's having a great time. One night he gets the call that every parent's dreading. Your son has been in an accident, he's going to be fine. However, I need to speak to someone about who can make their medical decisions. And the answer of, I am their parent, no longer applies when that child is 18. And you may have to go into court in order to make medical decisions on behalf of your adult child. So not only for your own planning purposes, but also for children, grandchildren, these are very simple documents. They are not expensive. Everyone over the age of 18 needs to have them to ensure that we are not having to go into court to have someone nominated to make these decisions on your behalf. So speaking of unpleasant things, what most people in California want to avoid is probate. However, a lot of people have no idea what is probate and is it good or bad? And the answer is it depends. Probate is a court overseen administration of a decedent's estate. And this happens if you only have a will or if you have no planning in place. So to start the probate process, if there is a will, that will be submitted to the court so that we can then have an executor nominated to handle the probate of your estate. If you have no estate planning documents in place, the laws of intestate succession will determine how your property will pass. And for some of my clients, that is worst case scenario. Basically, the law is that we will be looking to see who your closest lineal descendants are. Sometimes that's children, sometimes that's sibling, sometimes that is your fourth cousin twice removed. So if that is not who you want your assets to go to, it is vitally important that you have a document, whether it's a will or a trust, that dictates exactly how those assets should pass. Probate is a long process. I think pre-COVID, pre-court being on Zoom, you were probably looking at about a year and a half to complete a probate process. Moving forward during the pandemic, you are looking at even closer to 2 years in order to ensure that the probate will be finished. And the reason probate takes so long is because there are so many duties that need to be filed with the court. After an executor is appointed to handle a probate estate, they have to publish notice. And this is one of the most difficult parts for someone to swallow, is that everyone, not just your family, not just the court, will have notice of this. This will be published in a newspaper of general circulation. And the main purpose of this is to ensure that all creditors are paid. So there will be notice of the probate. Anyone can log on to the court website, see your will, see a list of all of your assets, and any creditors of your estate will be able to make a claim. And before a probate can be closed and assets distributed to your intended beneficiaries, all of the known creditors will have to be paid. So in addition to privacy, probate fees are probably the other worst part of going through a probate in California. Probate fees in California are based on the gross, not the net value of your estate. So if I have someone come in and say, I have a house that's worth $1 million, but I have an $800,000 mortgage on it, it's only worth $200,000. Not in the eyes of the probate court. When we are determining probate fees, if your house is worth $1 million, even if you have $1 million mortgage on it, we are going to be basing those fees on the $1 million. And these percentages that make up the probate fees of a California probate can get very expensive very quickly. For $1 million estate, you're looking at about $48,000 in probate fees before anyone is going to receive a beneficial interest in your estate. So how do I avoid probate? And obviously, the easiest way to avoid probate is to have a revocable living trust. In California, any real property and any assets that are cumulatively valued over $166,250 are subject to probate. This does not apply to assets that we were discussing earlier that pass by beneficiary designation or joint tenancy. But if I have a home that is in my name, or I have an investment account that is in my name, at my passing, if it is not titled in a trust, it will be subject to probate. I think another main reason is privacy. Trust administrations are done completely outside of the purview of the court system. So whoever I choose as my successor trustee will administer my trust without any court involvement, without any publication, and without my documentation and my assets becoming public record. And I think the other main reason is for planning, not just for tax planning, but also for your heirs, to ensure that they are receiving assets in an appropriate manner and at the appropriate time. So what is a trust? We throw that word around a lot. It has a lot of components, and we want to make sure that we understand what exactly a revocable living trust is. So the most important part is going to be who the trustor is, and that is who creates the trust. The trustor then contributes their property to the trustee. And the trustee is who is administering the trust. That is who holds legal title and is going to ensure that everything is invested properly, that a house is kept up, and they are holding it for the benefit of the beneficiaries. So in a normal revocable living trust situation, who are these people? Well, I'm going to create a trust. So I'm the trustor. I'm taking my house and giving it to myself as trustee. And I'm the one living in my house. So in a normal revocable living trust, when it is initially set up, you're serving in all roles. You are the creator as the trustor, you are the trustee as the person in charge of the trust, and you're also the beneficiary, the person who has access to utilize these assets however they deem appropriate. Keep in mind what needs to be put into the trust. That $166,000 probate limit is a cumulative limit. So while I may keep my day-to-day checking account and my car outside of the trust, my real property, my investment accounts, large savings accounts, all need to be titled in the name of the trust. A trust needs to be funded. And this is another common probate issue that I run into. A client comes into my office with their parents' trust. It is in a beautiful leather-bound book, beautiful paper, cursive handwriting. And my next question is always, what's in the trust? And I just get blank stares. So I ask a more specific question. Can I see a copy of the deed to their home? And lo and behold, the deed is in their parents' name. A trust is only worth the paper that it is written on if it is not funded. assets need to be retitled from you as an individual to you as trustee of your trust. This needs to be accomplished on real property through the recording of a deed. This needs to be done on your investment accounts by retitling them from you as an individual to you as trustee of your trust. And that change in title is what allows us to avoid probate. The trust is also revocable. And I think this is one of the biggest mountains to overcome for estate planning, is that how am I possibly supposed to know what I want to do in 5, 10, 20, 30 years? This is especially difficult for clients with younger children. I don't know what they're going to be like. Will they go down the right path? Will they be irresponsible? Will they have creditor issues? The most important thing to remember is that a revocable trust can be amended at any time. The best planning is for planning for tomorrow. None of us know how much time we have. If you have a plan in place that you know, heaven forbid, something should happen to me tomorrow, this is what I want to happen, knowing full well 5, 10, 20 years from now, I can change this. That is how proper trust planning will be accomplished. It's also important to know that these are all very flexible designations. Rather than having one child or one person serving as trustee, we can always have co-trustees, multiple people serving in that role. If there is not someone that you implicitly trust to serve as successor trustee of your trust, there's also private professional fiduciaries or corporate trustees to serve in that role. And this goes back to my earlier statement of, those beautiful trusts that don't have any assets funded in them. Be careful when you are purchasing a trust. A lot of attorneys who do not practice in estate planning will say, oh yeah, I can do a trust for you. It's not a problem. And unfortunately, it's one of those ticking time bomb situations where you then put your trust on your bookshelf. It looks beautiful. You never think about it, not knowing this trust was never appropriately funded or maybe appropriately drafted. Always ensure that there is proper asset ownership. This is also true for clients of mine who had a properly drafted trust done, but it was done 10, 20, 30, 40 years ago. The house that they lived in then is no longer the house that they live in now. The financial advisor and firm that they invested with at that time is not the financial services that they are utilizing at this time. I do it all at once. I'm going to suffer through doing my tax return. I might as well suffer through my estate planning at the same time. I sit down, I look at what assets are in my trust, and if things need to be added or things need to be updated, it's something that you really need to be reviewing annually, because an outdated trust is just as dangerous as an unfunded trust. And of course, proper beneficiary designation. Going back to our earlier discussion of retirement accounts, life insurance, beneficiary designation is a wonderful way to pass assets to your heirs because it is so simple. But it's also another one of those things that we need to check on. I cannot tell you how many people come in, they know that they are the beneficiary of their plan, only to find out that their spouse never changed the beneficiary after their divorce or after the passing of someone. It's a great exercise to go back and see, hey, when I set up this 401k with my employer from 20 years ago, maybe I named someone that I no longer want to be a beneficiary. So ensure that those beneficiary designations are correct. And of course, proper distribution. It's so easy to simply name a child as a beneficiary, but do you want a minor child receiving assets? Do you want a teenager receiving assets? It really needs to be considered. And of course, catastrophic illness planning. Make sure that your plan not only accounts for post-death planning, but also long periods of incapacity. Creditor protection, depending on your own personal circumstances, may need to be an issue that you raise with your attorney. And of course, estate tax planning, which we are going to get to in just a few minutes. I think it also needs to be a fee concern. A lot of times trusts become outdated because the client knows every time I call my attorney, it's $500. So I'm not going to call them. So if you are purchasing a trust from someone, are they funding it? Are they putting not only your property, but all of your financial accounts into the trust? What about an annual review? The tax laws are constantly changing. Is my trust from the 80s still valid? And if not, what are you going to do to fix it? What about a routine amendment? I have a new grandchild. I have a successor trustee who is no longer able to serve in that role. What is the process for changing my trust? And same with ongoing funding. If you move to a new home, if you open up a new investment account, is that firm still going to be there to assist with that transfer? In addition to a trust, you also want to have a will. And I know I mentioned earlier, having a will does not avoid probate. That being said, if you have a will and a trust, that is best case scenario. I like to utilize what we call a pour over will, which basically states all of my assets go to my trust. What a pour over will allows us to do is to use an expedited procedure through the probate courts to get assets that are not properly titled in your trust back into your trust without having to go through an entire probate process. So let's go back to this distribution planning. I now know the basics of how my trust works, but let's go back to these beneficiaries. I know that I will be the beneficiary of my trust during my lifetime, but unfortunately, I'm not going to stick around forever. So what if I want to leave assets to my kids? What's the best way to do that? Well, there are really four main categories of heirs. And the first is mature. This is a great heir. They're an adult, they're responsible. There's no reason for them to not have these assets. And we just put in the terms of the trust that this will be an outright distribution. What about not mature? This isn't necessarily someone who is juvenile or won't grow up. Maybe this is a minor child. In that case, we can put a term of years. You will not receive distribution until graduation from college. You will not receive distribution until attaining age 40. And postponed. These are my favorite class of heirs. This was a great kid, bright, went to a wonderful school, but maybe they graduated during an economic downfall. Maybe they graduated during the pandemic and really couldn't find a job in their field of study. This is when we can utilize what we call an incentive trust. So rather than them waiting to attain a certain age where they know they're going to get a distribution, the terms of the trust can instead say, I am only going to match your earned income. So if you go get a job that pays you $40,000 a year, the trust will then pay you $40,000 a year. And you will not believe how quickly these beneficiaries who swore up and down that it was impossible to find a job have one in just a matter of weeks. And disabled. These are beneficiaries who have special needs. They may be receiving needs-based public benefits, whether that's Social Security or SSDI. There is nothing more heartbreaking than an asset being left to a beneficiary and then that asset disqualifying that beneficiary from receiving benefits that they absolutely rely upon. And that's when we're going to be utilizing a special needs trust. This allows us to keep assets in trust for that beneficiary. However, they do not become a part of their estate. They are not counted as income or a resource to that beneficiary, so they can continue to receive those needs-based public benefits. And this special needs trust is simply used to augment the benefits that they receive. So let's touch on federal estate taxes. This has kind of become less of a big topic since the exemption amount has gone up dramatically. That being said, I still do have clients who are very concerned about estate taxes and they want to know how to avoid them. I think the easiest way to avoid estate tax is to leave assets to your spouse. There is an unlimited marital deduction of between passing assets to spouses. And of course, there's your unified credit or your estate tax exemption, which has gone up dramatically in the past decade. So right now in 2021, we each have an $11.7 million estate tax exemption. Anything under that amount, you are not worried about estate taxes. Anything over that amount at your passing will be subject to a 40% estate tax. And of course, in 2022, it's a big unknown. I, again, could talk about this subject alone for hours, but I'm sure, as you know, there is a bill in the House now that is trying to make very large changes to our current income, capital gains, and estate tax landscape. Things that you should be aware of: potential income taxes for high income earners may be going up. Capital gains tax rates may be going up as well, especially for those with adjusted gross income over $1 million. And of course, they are trying to lower the estate tax exemption. If the current bill passes, or some version of the current House bill does pass, we are looking at our current $11.7 million estate tax exemption being reduced to the previous $5 million exemption indexed for inflation. So probably about a $6 to $6.2 million estate tax exemption. So if you do have a large taxable estate, planning at this time before this potential bill is enacted, call your attorney. Very important. And of course, portability. This became law in 2012, where we were able to use what we refer to as a DSUI, or a deceased spouse's unused estate tax exemption. This basically allows married couples to double their estate tax exemption. So I mentioned earlier that each of us have an $11.7 million estate tax exemption. So if I pass and my surviving spouse files a federal estate tax return and elects portability, he can take my $11.7 million and have it available for his assets at his passing, basically doubling the exemption. What about charitable bequests? Leaving assets at your passing, in your trust, in your will, has enormous tax benefits. Leaving assets to a charity at your passing allows for a dollar for dollar estate tax reduction. So it's not subject to the adjusted gross income limitations that you're used to during your lifetime charitable gifting. If I give $1 million to charity at my passing, I am able to knock $1 million off my estate tax bill. So very important, check your documents, make sure that your favorite charities are being named as beneficiaries. So you say, Anne, this is great. I don't have $11.7 million. I don't really worry about this. However, I do worry about my legacy, and I worry about supporting my favorite charities while ensuring that I still have plenty of income during my lifetime. Can you make me a special trust? And the answer is yes. Let's say that you want to contribute assets to a trust that will increase your income, reduce your income taxes. I definitely want to avoid probate and estate tax, and increase the value of my estate. So let's look at an example. Let's say we have two spouses, one is 70 and one is 65, and they have an estate worth $2 million. And they currently have real estate that's worth $500,000, but they bought it years and years ago. It is appreciated greatly, and it has a tax basis of $100,000. So we know from our earlier discussion on capital gains tax that if I sell this $500,000 worth of property with a $100,000 basis, my $400,000 of appreciation will be subject to capital gains tax. And one of the joys of living in the beautiful state of California, after state and federal taxes, I am only left with $365,000 to invest. So assuming a 5% rate of return on my investment, I'm only receiving $18,000 a year because of all the taxes I had to pay when I sold my appreciated asset. So what if instead I give that asset to a special trust that's called a charitable remainder trust? So I transfer my property from me as an individual to me as trustee of my charitable remainder trust. My charitable remainder trust then sells that property. However, because it is a charitable trust, it does not pay capital gains taxes. So I then have that full $500,000 to reinvest. And assuming that same 5% rate of return, I am now receiving $25,000 every year instead of $18,000. At my passing, whatever is left in the charitable remainder trust will pass to my favorite charity, and everything is good. What about your taxes? You said, Anne, this would help me with my income taxes. How do we do that? Well, first, there are a couple rules. Putting assets into a charitable remainder trust, in order for it to qualify for a charitable deduction, at least 10% of the original value of the property has to go to charity. So if you have no charitable inclinations, this may not be the right trust for you, because at least 10% will have to end up in the hands of a charity in order for this to work. In order to determine how much of a charitable deduction you get to take, the IRS utilizes their actuarial tables, which basically determine how long they think you are going to live. So they look and say, okay, this is how long we think a 65-year-old and 70-year-old will live. If they receive $25,000 every year for the rest of their life, I believe that there will be $183,000 left in the trust after both of them pass. And the great part about a charitable remainder trust is that even what is left to the charities, that $183,000 after both spouses pass, even though the charity will not receive that, you are able to take a charitable deduction on this year's tax return for the amount that will not pass to charity until after both of you pass. So clients with highly appreciated assets who want to sell and reinvest, have a lifetime income stream, but also want to have a charitable deduction to help with their current income taxes, utilizing a charitable remainder trust is really giving you the best of both worlds. So I know that today was a bit fast and furious. As a huge supporter of the library, I did want to offer all of the participants a complimentary consultation with me. So I put my assistant's contact information up on the screen. So feel free to reach out if we aren't able to get to your questions, but I'm hoping that we at least have a few minutes to get to some of them.
All right, thank you, Anne and Rivkah. I think we're ready to tackle some of the questions that our audience has had a chance to think of. I know it takes a while to formulate questions when you have so much coming at you. Rivkah warned us about that.
I'm sorry.
For Rivkah, first of all, I want to say you have some good wishes from a former librarian and supervisor who says you're going to love this time off on your next chapter of this journey. As a former librarian, that's from Nefertari, who's been with us through all of these. So yeah.
Oh, thank you so much. I'm excited, scared, petrified, and exhilarated by what might happen next. Who knows?
Well, I had a question. Just when you say that your ethical will is in writing, because you're a writer, did you use a special format for that? Because you mentioned that there are online tools, or how did you go about getting that all out?
I typed it in a Word document. But now that I love that. Yes. Just breathe and go with the flow. That's beautiful. Now that I'm, going off to some new adventures, I hope to get a little craftier with it. And the photos, it's funny, I was doing the and my not quite 1-year-old grandson, I got a video last night of him being a rocket ship, and it sort of exemplifies everything you talked about, Anne. Just there's a lot going on there. Anyway, I think, for me, always starting, I'm a typist. I learned to type at a fairly young age. I think faster with my fingers. And so I was able to get it out. Then I can go back and refine it. But I put it in my folder at home that I have lovingly named If We Die, because it's how it was when Abe was still alive. And it's there for my daughter to read, hopefully not for many, many years, but just in case.
Yes, I like that, If We Die.
Yes.
So, And do you often see people come to you with as well thought out and ethical will to start their estate planning as Rivkah has done?
I wish. I really don't. I think that again, it's one of those subjects that we don't want to talk about. It's uncomfortable to even think about or contemplate. But I think the more thought that goes into it, the better result. And I think, like Rivkah mentioned, when you are going through loss or transition, having those things that you hold so dear, whether it's a family recipe or a photo, I can't tell you how much solace it can bring to a person. And I absolutely support utilizing a Word document, a folder, whatever you need to do to make it work. Your family will be eternally grateful.
Could I just quickly add something, only because my mother died in 1998 after a very short illness. And one of the things that I just found in an email from a few years after she died was her recipe for this thing we ate when I was a child that she called Swiss steak. And it's a funky kind of Midwestern recipe with round steak and peas and tomatoes. I don't know. We loved it. And, it just brought back all of those happy family meal memories. And it was just the other day that I happened to run across that email, and the email was from like 2004. So I think it's so important to be able to capture those things. And the other side of it is she died very suddenly, and they did not, while they had a trust, thank goodness, and it was very clear, and advanced care directives, they did not talk about what to do with their remains after they died. And that was a source of, I literally visited a mortuary 2 days before she died to set up her final wishes. And you shouldn't be in that situation. It's a gift to your children, right?
Absolutely.
For them to know.
Well, and I think too, having all that in mind probably makes the technical aspects of estate planning a little easier to do. So by the time you get to Anne's office, these questions are help guide you through some of the decisions you have to make. So we do have some questions from people who have some specific ones. So Melissa asked regarding capital gains, is for capital gains on a gift of property, does the cost of improvements count toward the adjusted basis?
It does. So that will increase your basis, the amount of the improvements. Good question.
Okay. And Catherine has a question about probate. What about accounts with a payable on death notation and beneficiaries? Are these subject to probate?
That is a great question. They are not subject to probate. They will pass to the designated beneficiary. My only caveat to that statement would be make sure that you also have a durable power of attorney for finance in case you need to access that account during the principal's lifetime. I can't tell you how many people put payable on death on everything. They have a period of incapacity. The child goes into the bank. They say, I'm the beneficiary. The banker asks for a death certificate. Oh, they're not dead. You don't have access to the account.
Okay. We have a question from Nefertari who says, my elderly but still sprightly grandma owns her own property, but she's starting to get forgetful. So my mother is her conservator. She has a will, but not a trust. Mom does her bills for her every week, and her name is on the bank account and can also control her monies. But I'm noticing my nephews and the other relatives of my brother might be trying to eye her property. Are we protected when she passes?
That's tough. So, the good news is that if there is a will, the property will probably be subject to probate. It will be overseen by the court. So the intended beneficiaries will receive those assets. I think as far as, utilizing any sort of undue influence or pressure, unfortunately, especially during the pandemic, there has been a huge rise in elder abuse. So my advice would be to just carefully monitor her accounts. If she does not have capacity, make sure that your mother, as the conservator, is on every single account, watching how that money is being spent, and then it will go to the intended beneficiaries.
Yeah, listening to what you said about the increase in elder abuse in the pandemic, it sounds like early communication and keeping that communication going with as many of your closest people as possible. Yeah.
Absolutely.
So Sharon asks, my mother wants to sell her house below market value to her grandson upon her passing. This intent is not in her trust. To save on capital gains tax, should this be included in her trust?
Yes, well, for two reasons. It should absolutely be in the trust because the property is not titled in the trust. Then we're in probate and we have all those fees and time. So 100% the property should be titled in the trust. And if they want to have the property go to someone for less than fair market value, that needs to explicitly be stated in the trust because the successor trustee will have a fiduciary duty to get the best price for the trust property unless that is specifically stated in the document.
Okay. And we have a question about, I believe that this refers to insurance that pays for legal costs. The question is, I have ARAG legal insurance. Do you accept this insurance?
I'm actually not sure. That would be a good question for my assistant. So I would give her a call and I'm sure that she can let you know.
Okay. And you talked a little bit, and I'm interested in whether people want to pursue this, but when you approach an attorney for a trust, should you ask what kind of questions should you ask up front about what you're getting for what goes into it?
Absolutely. So I think the first question I always would ask is, what area of law do you practice in? Was this your family law attorney who helped through a divorce and now they say they can print a trust off for you from the internet? This is an incredibly complex and ever-changing area of the law. Either go with someone who was referred by a family or friend who is trusted. If not, utilizing a certified specialist, then you are sure that you have an attorney who specializes and has a lot of knowledge in this area. As far as questions that I would ask would be, what is going to happen to my trust in the ensuing years? Will you be sending me an annual review letter about changes in the law? If I need to make changes in my trust, is that included in a flat fee or is there an ongoing fee for amendments or additional funding? And then normally my final question would be, at my passing, is your office able to assist with the estate administration or is someone else going to be in that area? Because I think for so many clients, it's not only knowing that they have a plan in place, but someone will be there to assist their family with the post-death administration.
All right. Well, thank you very much. Our time is just about up for what we had planned today, and our questions, I think we've got them all answered for now. Quick, before anybody thinks of anything else. No, I'm kidding. If they do, they can contact your assistant, and maybe we can put that in our chat, or people can certainly write us afterwards for information about how to take you up on that offer of a consultation. So if we could bring Rivkah back just to say thank you so much. And Rivkah, is there anything that you would like to add closing out?
Well, again, because this is my last time, especially presenting this workshop with the Friends, I have to thank the Friends of the Sacramento Public Library for being there every step of the way with me through my 12 years here and through their unflinching support of every crazy idea we have to try to make library services better, and actually for coming up with this series. The Friends of the Library look at the library and say, what do you need? How can we help? Where should we go? And that's exactly what you want in your funding partner and your life partner and everything else. So I just want to say thank you. And Anne, you really are a superstar. I love your talks.
Thank you.
You could have a podcast.
Yes, thank you, everyone. And thanks for joining us for the entire month of Money Matters. It's been a pleasure. And I'd like to thank, before we close out, Rivkah and the wonderful Sacramento Public Library staff who has helped to make this possible. I'll just say Morgan Pershing really quickly, because not to pick out one person. the library's community engagement manager.
And our fabulous IT staff
And
who
fabulous.
are there with us every step of the way. Robert, thank you for your service today.
I know Robert has made us all look pretty good today. Thank you. If you would like to review it or recommend this presentation to someone, it will be posted on the Sacramento Public Library's website. That's saclibrary.org, and on its YouTube channel later this week in a few days. So thank you again, everyone, for joining us. Thanks, Rivkah and Anne. And goodbye.